Welcome to the DoubleACS Daily News for January 3rd, 2017. Historian Dr. Gary L. Hylander recently finished up a series of talks on Supreme Court Justice John Marshall. In his talks, he analyzed several major Supreme Court cases and the effect that it has on the law today. To learn more, we spoke with him after the event.
Well, hi, good evening, North Attleboro, and tonight we've been at the North Attleboro Public Library, and what we've completed tonight is the third session of a three-part series on the John Marshall Court and the arrival of the Supreme Court as a co-equal branch of government. And I always like to say, as I told to these folks, that John Marshall is the finest Supreme Court Chief Justice, and what John Marshall was able to do, that John Marshall was able to elevate the role of the court into a co-equal branch of government, and with the Congress and with the presidency, with the executive branch. And John Marshall's court delivered over 1,000 opinions, and he wrote about half of them. And he enjoyed majority decisions, so the court could speak with one voice, not 6 voices. At that time, there were 6 justices on the court. The court case was Marbury versus Madison. And without getting into all the details, because you folks can research it as well as I can, but in the court case Marbury versus Madison, John Marshall, in a deft use of language and interpretation of the Constitution, that he developed the doctrine of judicial review. And by that he meant it is the priority of the court to say what's constitutional and to say what is repugnant to the Constitution, and that is Marbury versus Madison. Marshall saw the Constitution as a political document, as a social document, as an economic document, as a national document, to bring the court into the business of developing the country as it moved from the eastern seaboard over the Appalachian Mountains and into the early years of the country, the 1830s. A judicial nationalist, the most important Supreme Court Chief Justice. And right behind him, with an altogether different philosophy, a more expansive philosophy, because it was the 1960s rather than the 1830s, and that is Earl Warren, and the Earl Warren Court of the 60s and so forth. So these are the 2 major Supreme Court Chief Justices. In terms of, and this is where Earl Warren was so much not ahead of Marshall, but saw the court as a court of social engineering to make social law. And today, if you want to get a good handle on how part of the court today interprets the Constitution, it's called Reading Law. The book is called Reading Law by Justice Scalia. The recently deceased Justice Scalia. It's called Reading Law. As he reads the Constitution, it ought to be read in a very deliberate, careful way, original intent. The court does not make social law, it interprets the Constitution. So I recommend that to you just for an interesting counterweight to an Earl Warren, if you will. And we can close with this. Pay attention. It's important. It matters who gets nominated to the court. We're one person down. And we know that, I know, that already that the Donald Trump is vetting possible nominees. And that's going to be a Donnybrook. That's going to be a battle, because his type of a nominee will not be the type of a nominee that, let's say, Elizabeth Warren, will want on the court. And it's the Senate that approves the nominations. The president cannot appoint, he can nominate. And the candidate who's nominated must pass scrutiny by the Senate. And that should be a very interesting piece to watch come the new year. So see you soon, and good night, good luck, and be well.
That's it for today's update. For DoubleACS News, I'm Austin Ricketts.